Hello and welcome to today's webinar, the last in this series with Stream Sours and Con. Today we will cover exclusive data exploitation in data-driven markets, the competition and data protection conundrum. My name is Joanna Lane, editor of Chambers Canada, Africa, the Caribbean, the Middle East, and offshore. We have a really great panel today, and I'm delighted to be joined by Adlevo Capital Partner Falebi Ehsan, Data Privacy Solicitor Dara Agnes Ubia, and Stream Sours Senior Associates Chukwuyere Izuogu and Oyeni Emmanuel. Today's session will last 90 minutes. If you'd like to join the conversation, we are able to accept questions via the text box on your screen or by emailing events@chambers.com. If you have any technical issues, please click the question mark button at the bottom of your screen where you'll find some helpful tips. So moving on now to the session, I will hand over to Oyeni, who will be moderating the panel. Over to you.
Thank you.
I think you might be on mute. There you go.
Joanna.
Oh, you're welcome. There you go. Welcome.
Oh, can you hear me well? Okay.
Yes,
thank you very much, Joanna. Thank you for the introduction as well. It's been a pleasure to produce this webinar series with Chambers and Partners. This being the third session in the three-part webinar series. So thank you very much. And thank you to everyone who has joined us as well. We don't take it lightly that you have taken time out to spend with us today. We trust that the conversation will be fruitful and worth your while. So like the topic says, and the topic may be a mouthful, but in essence, we're looking to discuss competition in data-driven markets. And I'm joined by some of the best minds, I believe, that can speak to this topic. I mean, this lady and the gentleman with me on the panel have probably been on some of the biggest transactions in telecoms and tech in the last few years. And so I'm honored to be on the panel with them. Having said that, before we jump into the actual conversation, I just want to set the tone for what it is that we are discussing today. And to do that, because I imagine that we have, a mixed group here. So we have certain people who may be familiar with the topic and the theme of competition law, but then there may be some of us who are not too familiar. And so I will just create this scenario as a point of reference that will sort of underscore everything that's said, during this conversation. So let's imagine that there are two companies. There is the small company and then there's the big company. The small company is a group of young boys who just left university and they have a money spinner idea that they believe, will disrupt the industry. And, the model they will need to distribute their product or service will be the social network model, right? On the other hand, you have the big company that has existed for about 10 years. Can you hear me well?
Yes, we can.
Anyway, all right, thank you very much. And then the big company, has 20 million users on its platform and, has been around for a while. And then the big company goes to the small company and wants to acquire them. We see what you guys are doing and we want to acquire you, become one of our business units. And then the young guys say, no, we want to build it from the scratch. We want to, we believe in the long haul. And so imagine that the big company then hires maybe two engineers to create a similar product, right? In this case, of course, the law doesn't protect ideas. So they create something similar and then they deploy their services. Now, in that scenario, you have the small company doing the same thing, delivering that kind of service, and you have the big company, delivering that service as well. Now the question, so I'm not going to answer the questions. What would happen is I would leave the questions open-ended because those are the issues that the panelists will be speaking to. Now, pardon me, Yeah, the light just went off. Can you see me well, please? Okay, it's back on. So thank you.
Good to see you.
Thank you very much. All right. So in this my scenario that my story is getting too long, so I would run it up quickly. Now let's imagine, right, that the big company begins to deploy these services. It has the profiles of its users. You know, it can target ads and do everything to deploy the services properly. I mean, your guess is as good as mine that the big company probably has a better chance in that market, right? Now, the second scenario would be a slight tweak. And now imagine there was a body of laws, you know, that allows or that requires the big company to share some of its data with the small company as it's coming into that market, right? The questions then you then begin to ask is, will it be fair to the big company that having invested time and skill in building that data set or those data sets and all of that, and then it's required to share with the small entrant? You know, that's one question that's there. Another question you would ask is, what's the real benefit to the end user? That's you and I, you know, in this dynamics that I have highlighted. So these are some of the issues that will be spoken to by our panelists. And Mr. Esson will be going first. And he will be speaking to the issue of market definition, which is basically ground zero when you're discussing competition. You know, you have to determine what industry are you talking about, where's the competitive activity going on, and things like that. And so I will hand over to Mr. Esson now, because I think I've spoken for too long. Over to you, sir.
Thank you very much, Nii, and thank you everyone for this opportunity to speak to you all about this very interesting topic. I'm going to share my slides just now, so we can do what I'm about to talk about. Nii says I'll talk about market definition. That's part of what I'll talk about. But as a business person, I'm really keen to talk about value. You know, how do we get value from this business, this idea, and what we're talking about? So without further ado, you know, like I said, I'll talk about it from the point of view of a business person, an investor, entrepreneur, and an ordinary citizen trying to make sense of the dizzying change going on all around me. What do all these things mean, if they mean anything at all? Technology itself has become quite dreamlike, but a dream that intrudes into reality. We look at what happened in the last few weeks or months here. It looks like an alternative universe that we're in. For example, the rise and fall of cryptocurrencies is very interesting to many. The unfathomable experience of GameStop on Wall Street early on in the year, with people ordinary people taking on Wall Street and shorting the stocks of a little known or relatively unknown game retailer, and even more inexplicable, like things like non-fungible tokens, which I'm still waiting for someone to explain what they mean to me. So the question here is value. I said here we have a situation where many of the companies that are operating in data-driven markets today have market capitalization that actually rivals whole continents, right? So I have a list here that just shows what the market cap of different companies that we could say are in the data-driven market are, and comparing that to Nigeria's GDP and Africa's GDP. We can note that, for example, the TikTok founder, TikTok was started in 2016, right? And this gentleman announced his retirement yesterday, net worth of 44 billion, and said he's going to retire to a life of reading and daydreaming, right? The top 3 companies in the list here have a combined value that is about double the entire GDP of Africa. So how is it that a few companies, most of them less than a quarter of a century old, concentrate the world's wealth between them? I guess the answer lies in the new business models enabled by technology and the exploitation of data. So let's jump right into that topic. What are we saying when we talk about big data or about data in general at this time? Data has become ubiquitous in our lives, and this is what happens every 60 seconds. It changes every day. It becomes more. But we have 1.8 terabytes of data created, 11 million instant messages also sent, 695 updates, and so on. It's incredible how much data there is. And let me give you an example of how much data this is. One page of printed text has about 2 kilobytes of data. And so if you're going to print 1 terabyte of data, which is about half of what is produced every 60 seconds, you would require 500 million sheets of paper, 500 million sheets of paper to print 1 terabyte of data. So the 1.82 terabytes that we're talking about would require actually 1 billion sheets of paper, or a stack of paper that will be about 62 miles tall. That is simply incredible. Data is generated much faster than it can be stored. And the data is created by mobile, video, low cost of storage, and other infrastructure. And it's also characterized by what we call the several V's. Some use 4, 5, or 6 V's, including volume, velocity, variety, veracity, how true is this data, and so on and so forth. Now, how come data has become the new oil? Now, individuals generate a lot of data called a digital footprint in what they do day to day. So when I get onto the internet in the morning to check my emails, I immediately start to generate a trail of data of what I've done, what I start to do that day. And that includes things I leave on cookies that show me health and fitness data, location data, shopping, e-commerce, relationship data, and all kinds of preferences and connections. The list is actually endless. A few years ago, actually maybe 10 years ago, a student in Australia asked Facebook for all the data that they had on him, and he received 1,200 pages of information covering everything he had done since he joined the platform. They knew him better than he knew themselves, than he knew himself. But despite the value or the volume of individual data that we generate, this by itself is not that valuable. Granted, it can be used to better target advertisements to us, but not many marketers will be interested in my individual preferences. But by aggregating individual data, cross-reference the aggregated data with other types of non-personal data like weather, geospatial data, location data, and so on, you can generate all kinds of insights that become extremely useful. In fact, when you look at the value of data, some research showed that there are 8 major types of online platforms creating this very valuable data. I'll just read through them quickly. E-commerce online platforms, online resource sharing platforms, e-financial service online platforms, online social network service platforms, that's probably like Facebook, online auction and matching platforms like eBay, competitive crowdsourcing platforms, and non-competitive crowdsourcing platforms, and the online search platforms being the 8th one, and that's like a Google. I'm not going to go through all of these, but some of the companies that exploit big data are here: Google, Amazon, Uber, Netflix. And I'm going to go through very quickly a few of the ways in which data becomes valuable in the hands of the exploiters of this data. When Amazon gets their hands on your data, what actually happens? So in this slide, I won't spend so much time, but I'll just talk very briefly about 2 of them and spend a lot of time on the third, which is Google. So Amazon, from a very humble beginning as a bookseller many years ago, now provides about 10% of all US retail sales. And it does that starting from here, the data click stream, purchases, reviews, locations, and over 100 million Prime users who provide the data that allows Amazon to create value for third-party sellers, who then allow Amazon Marketplace to capture value and provide some value back to the consumers in terms of shopping benefits like time savings, cheap prices, and so on and so forth. LinkedIn, our second example, is even more perplexing. In LinkedIn, when we're there, we don't really see ourselves carrying out any commercial transactions. I posted yesterday, for example, a link to this seminar or this webinar yesterday. and I got a few calls from people who said, oh, that's interesting, we're going to join in. Now, where is the commerce in that? Nevertheless, in 2015, LinkedIn generated about $3 billion in revenue, and the following year was bought by Microsoft for $26.4 billion. Obviously, they're doing something right. There's something they're selling. And somebody said that if you don't know what the product is, then you are the product. Let's go take a look at Google, which is really the big kahuna, or one of the biggest kahunas in this market here. So Google is the most popular online platform in the world. It provides individuals a convenient way to get information instantly. And on the one hand, it allows advertisers and content providers to reach a very large user base. And then the data targeted ads can increase the advertiser's return on investments. These content providers can also add the search functionality to their web pages to monetize their content. Now, what happens here is that the more you use Google, the better the advertising algorithm becomes. And so it's a virtuous cycle for Google that the more we use it, the better it becomes. The better it becomes, the more we want to use it. And again, it becomes better, and as you can see, creates more and more value, essentially accruing to Google. For example, in 2017, a company paid Google $3 billion for AdWords advertising. One company paid $3 billion, and that was part of a $95 billion revenue in 2017. So what I've tried to do in this first part of my presentation is to say, what is the value of this data? And to highlight the fact that data by itself, my data, is not valuable. When it gets aggregated and analyzed and repackaged and cross-referenced and collaboratively filtered and so on, it becomes very, very, very valuable. And so we'll take some definitions and talk about where we are today in terms of what this means for a data-driven market. So a data-driven market is a market where the cost of quality production decreases by the amount of machine-generated data or user preferences or characteristics, which is an inseparable byproduct of using the services offered in such markets. This is an important point. The data that we generate when we go to Google to search is not the purpose. That's not why we're there. It's a byproduct of us trying to find something. So I want to find an article about data. I go to Google, I put in data, and then I start to go around looking for things, and I generate a huge amount of footprint, digital footprint. That byproduct is what Google then uses to monetize its platform. And exclusive data exploitation is exactly this process, where tech companies are collecting the data via their platforms, mobilizing this data using analytical tools and algorithms, and using that collected data for third parties to improve their products and services without, and this is an important point, without disclosing to the users of the platforms how exactly their data would be used. So very few of us actually understand how our data is used when we go onto a platform. In fact, if we were to try to read all the consents we give, you go to a website, it says, do you accept cookies? And you say yes, because if you say no, you have to then choose exactly how they should deal with you. You say yes, and when you say yes, you end up spending just giving away your data, essentially. If we were to read all those things, it would take us 76 days in a year just to accept consent. And on the left-hand side of this slide, we can see how data analytics allow us to change the business models that then change the nature of competition. So the questions we ask today are whether exclusive data can harm competition in the data-driven markets, and whether the extant rules of data processing can constrain anti-competitive conduct arising from exclusive data exploitation. Well, exclusive data exploitation, can it harm competition? I think Nee's example says yes, definitely it can. And can data sharing, if you give that small company all the data that the big company has, would that then permit the small company to compete? Well, I'm not going to try to discuss legal matters because we have a lot of very highly capable legal minds on this panel, and I'll leave that to them. But I'll just mention that in a very highly publicized case many years ago, the European Commission found Google guilty of excluding its rivals in the Android licensing case by adopting a strategy where they didn't allow other people to access the data. However, though they imposed a hefty fine, the Commission did not impose a data sharing remedy. So in this case, the competition law or the competition regulator found an infringement and actually fined Google, but did not think that sharing the data was a remedy to the loss that had been suffered by the competitors. There are many cases that we could discuss. Like I said, I'm not a lawyer, so I'm not going to spend too much time, and I think my time is nearly up here, looking at all these cases. But I'll just note that Facebook has had a case where, initially they were in violation of the GDPR, which is data protection regulation in Europe. This was then overturned in the High Court and then taken to the EU court and so on. The point I'm trying to make here is that it is complicated to determine what the remedy should be. Again, the UK digital advertising, similarly, they had a situation where they wanted people to have choice, and that there was a conflict if you allowed people to have exclusive rights to the data that they generated. If we go to the next case, Facebook versus Apple, this wasn't really a case. Essentially, what happened here was that Apple gave its users a choice, and it said that you can decide whether you wanted to have tracking on your phone. The interesting thing is that 85% of users opted out of data tracking worldwide, and 94% users in the US. Here is a huge blow to Facebook, which someone says at the bottom of this that over the next 10 years, people will learn the importance of privacy in their data, and that also some things that Facebook itself might be out of business because of changes like this. So what exactly is the conundrum that we are facing, that we're talking about today? Well, there's tension between data protection, competition, and consumer protection throughout the world. And this is some of those questions I'll repeat because, as I said, not being a lawyer, I can only just think about these things, and we will discuss them throughout the rest of the session. If we look at current data regulation in Nigeria, again, I'll leave this to my colleagues on the panel to discuss it, only noting that our laws are essentially a copy, in my layman's opinion, of GDPR. I mean, not an exact copy, but there's not much difference in how the laws are laid out and what remedies and so on that they provide. And on competition law, our FCCPA, which is the older piece of legislation, there was no contemplation of the current issues when that act was promulgated. In contrast, in South Africa recently, they released a comment, a publication for public comment on competition and in digital economy. And they noted that the digital economy provided an opportunity to reverse the scourge of unemployment, inequality, and poverty in South Africa, but that in order to harness these benefits, South Africa had to create a commercial and regulatory environment that would extract the benefits and distribute them in a way that ensures inclusive growth, increased and meaningful employment, equality, and shared prosperity. They also noted that for all its promises, the digital economy in developing countries already threatens a new era of global concentration, and this is very important. And with it, the further marginalization of vulnerable countries and businesses. Therefore, intentional regulation is required to avoid outcomes that could harm the development of small businesses, consumers, and ultimately the economic growth so needed in South Africa and every other developing economy. So this is our discussion today. I'm going to conclude with my concerns, which echo what was in that report. Essentially, there is a real and a growing data divide that is consequent on the rise of data-driven markets that we all participate in, and the exclusory exploitation of this data that the players aggregate, analyze, monetize. And this is just on the back of the digital divide, which is still very much in existence. There's a report from the World Bank, World Data Reports 2021, Data for Better Lives, which spotlights some of these issues. And there are gaps in the value chain for all of us in developing economies, which start from generation through to aggregation and to analytics and monetization. All of these things based on things like lack of infrastructure, lack of competent people, and lack of national resolve that are required to tackle the issue. Without thinking very deeply and executing very rapidly, this data divide is likely to become a huge chasm, which might drown many of us, many countries in an ocean of data, but no information. Our laws, regulations, and policies are a critical part of this effort. So with that, I'll stop, and thank you very much for listening to me.
Thank you, sir. Thank you, sir. Thank you very much. So then Darren will be coming up next. I think it's a perfect segue into Darren's presentation. Mr. Son had asked, a question about the value, and I think this value in data and of course in the processing that happened. So Darren will be speaking to data protection, right? And she'll be talking about the character of data that makes it a resource or not for competition. So Darren, over to you. We're a little out of time, so please, you could be quick so that we could have enough time for Q&A. Thank you very much.
Thank you, Nii. I'll do my best. Can you hear me?
Yes, we can hear you clearly. Thank you.
Thank you, Nii, and thank you, Mr. Folabi, for that opening remarks. That was really thought-provoking, very insightful. Before I begin, I want to say a big thank you, first of all, to the audience. Thank you for joining today's webinar, and of course, to the organizers for inviting me to speak at today's webinar. The subject of data protection and competition law is a subject that is engaging regulators, lawmakers, policymakers around the world. And the conversations flowing from today's webinar will certainly contribute to the landscape. Thank you. So today I'll be looking at data and data protection. I'll look at Nigeria's data protection regulatory framework, and I'll draw parallels with the EU's framework. And the reason for that is that the EU has some of the most comprehensive data protection laws in the world. And then I'll explore the question, does data protection law promote competition law objectives? And I'll tell you now, I think potentially, but like with everything that has to do with data protection, you have to think about the policy objective of data protection law, which is the individual, and putting individuals at the heart of whatever is done with their personal data. So data, So data, as we all know, is information. But there's been quite some interesting terms that has been used to describe data in the industry. So it's been described as the new oil, and Mr. Folabi spoke to that. It's been described as the fuel in the digital economy and everything else that I've listed on this slide. And the reason for that is that the economic strength of online market is increasingly determined by the volume and the variety and the quality of data that these businesses hold. And so online businesses like search engines like Google and Bing or social networks like Instagram, Facebook, LinkedIn, or e-commerce platform like eBay, Amazon, Jumia, they all have business models that depend on acquiring and monetizing data, all sorts of data. And last but not least on my slide is data as a currency for free services. And that can be seen with many of the so-called multi-sided platforms. And these are platforms that bring together users and advertisers in one space. And we've all signed up to these platforms, Facebook, Gmail, and Yahoo. And we say to ourselves, "Oh, Facebook is free, Yahoo is free," But we know that we had to surrender valuable personal information in order to utilize those services. And of course, the benefit to us is that we get more relevant search results, we get richer social interactions, we get good or better e-commerce or shopping recommendations and so on. The benefit to the advertiser, like Mr. Folabi pointed out, is that they are better able to target their advertisements. So they are no longer broadcasting their adverts. It's now narrowcast to the specific audience that they're targeting. Another reflection of data as a currency can be seen in the EU's directive on digital content. So Article 3 of that law sets out the scope of the law, and it says that the law applies where digital content is provided to a consumer, and in exchange the consumer provides payment or provides personal data. So that's a law that recognizes data as a currency for free services. And if you're paying close attention, you'll find that a lot of companies, even traditional companies outside the digital market space, are in different stages of what they call a digital transformation journey. And it's all about data. And they're investing quite heavily in building data lakes and in data mining and data warehousing. It's all about data. And particularly in the critical infrastructure space, a lot of these companies, like hospitals or oil rigs, are moving from cloud computing models to edge computing because they want to be as close as possible to the edge of the terminal device where data is generated. They want to harness data in real time. It's all about data. I'm not going to go into the separate but equally relevant industry of data brokerage, where our data is being bid in real time as we browse the internet. Nii, can you see my slides?
Yes, I can see your slides, yes.
Right, okay. So personal data. Personal data is a subset of data, and section 1.3, article 1.3 of Nigeria's data protection regulation defines personal data as data that relates to an individual, to an identified or identifiable natural person. The identifiable bit is very important because it highlights the less obvious types of personal data. And I like the way the law puts it. Say something along the lines of identifiable, in particular by reference to an identifier like a name, an identification number, location data, or an online identifier, and then it goes on to list different indicators of identifiability. And I can tell you, in my years of practice as a privacy solicitor, I keep getting asked the same question over and over again by product owners, product developers, and innovation teams generally. And they say to me, "Oh, Dara, there's this product that we're looking to deploy. We're not collecting any personal data whatsoever." No. Dara, all we are collecting is location ID. It's anonymized, right? It's not personal data. Wrong. It is personal data. A, because the law so expressly provides in that section that I read out. But separately and practically now, if you gave me really precise longitudinal geolocation data relating to anybody, of course, over a specified period of time, I could tell you with mathematical accuracy who that data relates to. I could tell you where they live. I could tell you where they work. I could even tell you their religion, because it's all there on the maps. I can see that on Fridays at a certain time, they're at the Central Mosque, Abuja, or on Sunday morning, they're at Church of the Assumption in Falomo. Now, the law categorizes data into two broad categories. You have personal data and sensitive personal data, or special category data under the EU's GDPR. And that's data that requires a heightened level of protection. So things like health data, genetic data, sexual orientation, trade union membership, and political opinions, and so on. But beyond the statutory classification of data, and this is practically now, data can be categorized into three broad buckets. So you have the volunteer data, which is data that you provide to an online business or to any business, but particularly in the online space. So an example is I go to jumia.com, I type in my name, Dara Ubia, I type in my address, number 1 Ozumba Mbadiwe, Victoria Island, I type in my date of birth, 1st of January 1900, I submit. All of that data is volunteer data. In the next bucket, you have observed data. That's data obtained by monitoring my behavior. So following on from that example, say I decide to put things in my shopping basket. I put in a packet of blue balloons, I put in a religious book, and I put in a lawnmower. And then I change my mind actually, and I take out the balloons. All of that information, what I bought, what I was going to buy, but changed my mind, all of that is observed data. And in the third bucket, you have inferred data or metadata, which is data about data. And that's data that's derived from analyzing the first two buckets. So going and following from my example, the inference that can be drawn is that I belong to a certain religion connected with the book I bought, and maybe I live in prime property and I've got acres and acres of greenery, and possibly, there's a lot of inferences that can be drawn. And maybe that I'm planning a birthday party for maybe a male member of my family at this time of year and so on. And so when I log back into Jumia, I start to see other related advertisements like blue confetti or weed killer sprays and so on. Now, all of that data, volunteered, observed, inferred, personal, sensitive, all of that is my personal data. And that is the focus of data protection law. Again, the policy objective of data protection law is me, the individual, putting me at the heart of whatever happens to my personal data. Next slide. Now, looking at Nigeria's data protection framework, so a lot of countries have taken a human rights-based approach to data protection and have recognized data and data protection as a fundamental human right. In Europe, it can be seen in Article 8 of the Council of Europe's European Convention on Human Rights and Article 7 of the European Charter on Fundamental Rights and Article 16 of the Treaty on the Functioning of the EU. And Nigeria is no exception. So Section 37 of the Constitution of the Federal Republic of Nigeria recognizes and guarantees the privacy of Nigerian citizens, their homes, their correspondence, their telephone conversations, and their telegraphic communications. I don't know who's sending telegraphs, but it's all recognized under the Constitution of the Federal Republic of Nigeria. And now these countries have gone a step further to enact laws that are specific to data protection. I like to think about it like building blocks. So at the bottom, you have the Constitution. On top of that, you have the NDPR and the Act or the bill that is going through the legislative process. And then on top of that, you have the implementation framework or the guidelines or whatever published by the regulators, NITDA, NCC, and so on. Now, within the second block, you have all of the rights that individuals are entitled to. So things like the right to object, the right to be forgotten, right to erasure, the right to access their data, right to restrict processing, and so on. And then you have all of the data protection principles. I'm not going to cover them on this slide. So things like data minimization, purpose specification, data security, accountability, and so on. And all of these principles and the rights and so on underpin or reinforce data protection. In terms of the basis, so the basis is connected to the principle. So basically, whatever you do with personal data, you need to have a basis for it. And data protection law recognizes a number of legal bases. Next slide. Now the question, does data protection law promote competition law objectives? I think potentially. One of the rights that data protection law gives is the right to data portability, which is the right for users in certain circumstances to move or to transfer their data from one service provider to another. And because that right allows people to easily switch between services, it could be a solution to the problem of user lock-in. And so, yes, it could promote competition law. However, that right has certain limitations. First of all, it's an individual right, so it's only available to individuals. A company cannot claim access to data on the basis of data portability. And then secondly, the scope of the law only covers volunteer data. Remember when I spoke about volunteered, observed, and inferred data? This right to data portability only allows you to port the data that you volunteered to a business. Now, that gap also exists under the EU's GDPR. But a later legislation, the Digital Content Directive, has sort of plugged that gap. So Article 16 sub 4 of the Digital Content Directive says that data apart from volunteer data, so any other data, the observed, inferred, can be ported under that directive. And then another limitation of that right is that it only covers data that is processed on the basis of contract and consent. Remember in the previous slide, I talked about the different bases for data processing. Well, this right only allows you, it's very limiting in that sense. And then there's the issue of interoperability of platforms. So for data, for you to port data or for data portability to happen, it requires a level of compatibility between networks or between IT infrastructure. And closely linked to that issue is the issue of technical feasibility. It's not on my slide, but the way the law is worded, it says that you can port data where technically feasible. And it sounds like something that an incumbent could say, well, I'm not porting data because it's not technically feasible. And then last but not least, of course, it's of very little effect in network industries like WhatsApp. Where are you porting your data from WhatsApp to? Because the utility that you derive from networks like WhatsApp and so on increases with the number of people on that same network. And I'm moving to my last slide because of apologies. So the last slide, so these are the data protection principles that impact competition law. So part 2 of Nigeria's data protection regulation lists a number of principles, and I think it impacts competition law adversely. So the first is the duty of care, which says that anybody in possession of or entrusted with personal data owes a duty of care to the individuals to whom that data relates. And it's a principle that can be relied on by an incumbent to say, well, I'm not granting you access to data because I owe a duty of care to the individuals, and I don't know what data security measures that you have in place. Lawfulness is another one. And so the way it's worded in the NDPR, it's like a triple barrel principle. So it's specificity, lawfulness, and legitimacy. And within that principle, it says that if you're entrusted with personal data, you should not transfer that data. And then the last one is accountability, which says that anybody processing personal data is accountable to the individuals to whom that data relates. So all of these principles can be relied on by an incumbent to deny or to refuse access to their database. And so that's my last slide. But for completeness, I must say the extent to which data protection law promotes competition law depends on the extent of cooperation between the specific regulators, in this case, the FCCPC and NITDA. And I'm not aware that the FCCPC has invited NITDA or has involved NITDA in any competition law review. And that's understandable because, quite frankly, not all competition law issues or competition law reviews or matters raise issues of data protection. And I know there's been a lot of calls from data protection advocates saying you must consider data protection in competition law matters. And in spite of all of these calls, the US Federal Trade Commission and the European Commission have said that competition law review is a matter that falls primarily under competition law, and that data protection matters should be considered under data protection law. So it's an ongoing debate, but the good news is that there's growing involvement of data protection authorities in competition law matters. I know the question that everyone's thinking right now is, Dara, tell us, has there been cases where the competition law authority has mandated or required an incumbent to share data? And the answer is absolutely. There are a few cases like that. But in all of those cases, so the open banking case, the case in the UK where the energy suppliers were required to share energy consumption data. In all of the cases, the right of the individual was put at the heart of those decisions, and the choice was for the individual to make whether they want to share their data or not, because data and personal and data protection is a fundamental human right. Thank you, Nei.
Thank you, Dara. I think at some point we should look out for your book, because this was a very engaging presentation. Thank you so much. I will just, before I hand over to Chooks, I will just want to say to the audience that please, you can throw in your questions. You know, there's a provision made for you to ask questions. I can't promise that we'll run through everything, given the limited time that we have. But subsequently, we will share the answers or the questions with the speakers of the panelists, and then we will provide the answers to your emails, the ones you used to register. And so now I would hand over to Chooks, straight up, so that he speaks to the interplay between data protection and competition. Over to you, sir.
Thank you, Nei. Good morning, everybody. Can you see me? Can you hear me?
Yes, we can see you. Yes, we can hear you.
Okay, so I'll just dive straight into it. Dara, thank you for having an excellent discussion on the data privacy issue of having access to personal data. Now I'll be looking at the competition aspect. Basically I'll be looking at it from the perspective of ex post and ex ante intervention. What kind of market risk would occur that would impede competition or limit contest within the market. Ex post takes the view that an anti-competitive conduct has already happened in the market, and competition law definitely intervene. They stop to that conduct or to reset competition within the relevant market. Then ex ante intervention takes stock of the prevailing market condition. It takes stock of whether market failure exists, are there barriers to entry into that market, and is concerned that it could present opportunities for firms in that market and in data-driven market to engage in an anti-competitive conduct. So we'll be looking at what kind of issues, competition issues arise, from having access to this and how competition law intervene. First things first, as a ground level, let us look at this is based on conclusions from the different studies that have been done by academics, done by regulatory authorities, and recent by parliamentary investigation in the United States. So what is the relationship? Sorry, am I still on? Can you hear me?
Yes, we can. Yes, we can. Yes.
Thank you. So this is based on the conclusion from these studies, the relationship between privacy and competition. Basically, privacy now is seen as an element of quality, and quality itself is an element of non-price competition. So what it means in data-driven markets is that the firms now engage. What it means now is that the firms now compete on the basis of privacy in data-driven markets. Essentially, if there's weak competition in that market, it obviously translates to weak privacy protection. Then also there is this conclusion that says the fewer the firms operating in the data-driven markets, the fewer privacy choices the data subject of the consumers have in that market. We've seen that case being made in the United States, where attorney generals of several states brought a case against Facebook, and they argued that the acquisition of a competitor in that business eliminated privacy choices for the data subjects. Then obviously, there's also the conclusion that says firms operating in data-driven markets, if they merge, it gives the opportunity for these major firms to amass a humongous amount of data that it could process, and that could lead to undermining either data protection rules or competition within that relevant markets. And we've seen that case being made in the Google and Fitbit merger, where there were concerns about Google as a person with people's merger friend having access to information held by Fitbit. I understand that this transaction has been approved. Then obviously firms operating in firms that have exclusive access to this data, so it solidifies their market power from a competition perspective, and it entrenches their dominance. This is what we are looking at now. We are looking at market power issues arising from having access to this data. It's all about competition. For instance, we've all spoken, Dara and Mr. Iso have spoken excellently about how data plays a role in having access to this data plays a role in competition. For instance, I'm an incumbent platform. I have access to a lot of data, personal data of visitors that come on my website. This information may not necessarily be available to merchants who depend on me for core platform services. So can I use this information? From this information, I'm able to get an insight into what's near accurate insight into what the consumers want. And I'm able to target them with services that fits their shopping preferences. Obviously that gives me a leg up in the market. Then there's also the question about barriers to entries. Having that results from having access to the data. In this same example I give, there's a feedback. I have a platform. The platform attracts a lot of consumers, the data subjects. I extract information from them. When I extract information with them, I use this information to provide services that attract users to this platform. We see there's a vicious circle going round and round, and that entrenches their dominance and erects barriers to entry into that space as well. So from an exposed perspective, it becomes a question of market power. Then from a competition perspective, the competition law in Nigeria is the Federal Consumer and Competition Act. What's the meaning of market power? And the definition is also very much consistent with what the literature provides. It's the ability of a firm to act in a particular space without being constrained by either the consumers or its competition. And obviously, there are certain factors that are also used in our assessment into whether a firm has market power. And there's a size market share holding, which at this time the competition authority has not specified. But in the communication sector, we have a 40% shareholding that gives an indication that you exercise market power. And obviously, for the purpose of our discussion, access to data, because we see that as solidifying, entrenching your dominance in that market. And there is, very importantly, there's a question of defining, Mr. Isom has spoken about market definition, but now we'll be talking about market definition for competition or economics purposes. And obviously, market definition under the Nigerian Competition Act has two elements. The first element is the product market. The product market could be defined on the basis of what consumers see as a substitute, on the basis of how fast suppliers will be able to change production without incurring additional costs. Then there's also certain specific nature of the digital markets that must be taken into consideration when defining markets, and this is very important for economists. One of them is whether the platform itself is two-sided. And most of these platforms in the digital economy are two-sided, like Tara just mentioned. For instance, we have the search engine, whereby on one side of the platform, we have users who make search inquiries, and on the other side, we have companies that take up advertising space. Now, there is academic arguments and cases from the United States, particularly, that says when trying to sustain a claim of monopolization or market power, you need to be able to establish that the harm itself occurred on both sides of the market. Then there's also the question of whether there exist opportunities for single homing or multi-homing. Single homing is when users express strong preference for using just one platform, irrespective of the fact that it is a brand. If that were to be the case, then obviously that platform itself constitutes the relevant product market. And there's also a question of whether the platform itself is zero priced. Just like Dara spoke to right now, she says our personal data is what we use for exchanging, or for using these particular platforms. So it could be that, yes, it's not zero priced per se. But the thing is, when defining the markets, don't be too narrow, don't be too wide. There's obviously another aspect of market definition, the demographics of the market, which speaks to how, to what extent goods and services we have in a particular region. And when we take that in consideration with the internet that is borderless, we need to be careful in trying as much as possible to restrict the geographical boundaries to what it actually is, in reality, in practice. then the question now becomes access to data. We understand it solidifies market power. Could it also lead to unlawful or excessive processing activity? From a data protection perspective, it's a question of consent. Whether consent, has been obtained, consent that meets the standards set out under the data privacy law, or it could be that data minimization. You've used more data than you're supposed to use, more than is adequate for the purpose in which you pursue. It could be a question of purpose limitation in the sense that you're permitted to use data in a particular way, but you deviate from that commitment. That's the data protection question, respecting how excessive access to this data. But from a competition perspective, if exclusive access to this data translates to unlawful or excessive present activity, which is a question of consent. From a consumer protection perspective, now becomes a question of consumer choice. Because that is the sole objective of consumer protection or competition law. It's all part of the consumer welfare standard. And if that becomes the case, then it could translate under the Competition Act in Nigeria to an unfair trading condition, which is prohibited. But then it has to satisfy several elements as set out under Section 72C of the Competition Act. The first one is that it must be exclusionary. Competition harm could either be exclusionary in the sense that it only affects the market of business rivals within that relevant market. That's what the law says. But there's a paradox to it. It could also be exploitative in the sense that the data subjects that have been affected in this particular instance. But then it's also the exploitative effect translates to an exclusionary conduct. This should be done on a case-by-case basis. And there are several academic studies to back this up. Then obviously you need to make the question of the anti-competitive effect of that market. If it's a question of consent, from a data protection perspective, then that translates into choice. Then it's a question of whether consumer choice has been constrained. Then also look at factors, whether it erects barriers to entries, and the extent of market foreclosure. And lastly, the last link of it is that you need to prove that it is devoid of any technological efficiency or pro-competitive gain. That is self-explanatory. So that's the ex-post approach for competition, how competition will intervene to relate people who have market power, and they can misuse this market power in data-driven markets. But what is an ex-ante approach? Just like I spoke to, an ex-ante takes a forward-looking approach. It's afraid that the present market conditions may present opportunities for the incumbents to engage in anti-competitive behavior, and we need to stop that from happening. When deciding whether to intervene on an ex-ante basis, they look at a lot of factors. One of the factors are erections. Are there structural barriers, or are there some sort of barriers to entry into that market? We've spoken about this, that having access to data on exclusives creates barriers to entry for data to the market. Then obviously traditional competition assessment investigations take a long to run its course. So by the time the investigation is complete, found out that the harm in the market has already gone to such an extent that it cannot be salvaged. So you need to act fast. So those are the elements that are taken into consideration, whether to intervene on an ex-ante basis. And that brings us to monopoly investigation under Part X of the Competition Act in Nigeria. Now, one of the goals of this monopoly investigation, it is to prevent adverse effects brought about by a monopoly situation. Now, the reference to prevent itself, it's very much consistent with the ex-ante approach, as I've just spoken to earlier. It's preventive. It takes a preventive stance rather than curing what has already happened in the market. So I would make a very strong argument that on the basis of ex-ante, a monopoly investigation provided for in Part X covers that. So the procedure basically is for the competition authority to establish that a monopoly situation exists. But there was no definition for this in that act. But then if you look at the dictionary meaning of what a monopoly situation entails, find that it's not so different from when market power exists. Then the beautiful thing is that the competition authority has very broad powers to make remedies, that could prevent this adverse effect brought about by a monopoly situation. And it's not going to do this without taking into stock what's been happening in different parts of the world. We see this data, the kind of risk it presents to the market. For instance, we've seen in the European Union Digital Markets Act, which seeks to designate certain platforms as gatekeepers and also imposes ex-ante obligations on them, how they deal with certain types of personal information. And we've seen the inquiry in the United Kingdom as well, where there was this conversation about data and the kind of remedies that could be applied to set competition in that market. And then these are things, live discussions going about in different parts of the world. Back in Africa, we have the South African Authority also conducting an inquiry into access to data and what kind of market risks it presents. And I understand recently there were some major guidelines that were recently released that is applicable to mergers of oil in digital markets, and obviously data access to this data is also a question here. So basically having these things and this experience from different jurisdictions, taking it in stock, it's not unusual for the competition authority because they have broad powers to mandate the sharing of data, and this is very similar to the data portability that I spoke to. Basically, and I quote, now this is to address the imbalance that data ownership, control, and usage create in certain sectors. Now, this statement was made by the CEO of the FCC, which is the Competition Authority, at a seminar on big tech and antitrust, held at the Law School sometime last year. So it gives a mindset that yes, they see the importance of democratizing access to this information, and yes, they also see the importance of everybody having, all participants within that space having access to it. But from a data protection perspective, the concern here is that purpose limitation can actually be a large mandated sharing of data. But the rule in Nigeria, when there's a tension, a conflict between the primary legislation, which is the Competition Act, and the MDPR, which is a subsidiary legislation, the primary legislation would prevail, would supersede. But I would assume that the regulatory authority, as a diligent and a very good regulatory authority, would also ensure that the privacy rules are complied with as well. So there's a list of orders, because the Competition Authority has powers to make orders, broad powers to make any orders that it thinks would be relevant for setting competition and during an ex-ante intervention. So these are just to give you the mindset of the next stage is for the Competition Authority to submit this report to the tribunal. The tribunal, by law, is authorized to enforce these orders. So that's now to give you a typical example of what's been happening in Nigeria. A perfect example that could be the draft open banking framework, which was issued by the CBN, which is the Financial Service Regulator. Basically, what that speaks to, it's an order that seeks to democratize access to data, including personal data within the ecosystem participants as well. Then also takes privacy interest, privacy interest into consideration. Basically, it also makes consent provisions about consent to be acquired from the data subjects, and also specify mandates that data privacy rules in existence will be complied with by the ecosystem participants. So that's like a standalone document that deals with data, personal data, and on one hand ensures that competition aims objects are met, and on the other hand also takes privacy interest into consideration. So thank you. This is where I come to the end of this.
Oh, okay. Thank you. I didn't want to interrupt. I was just about to jump in because we have questions coming in, and I just wanted us to jump right into it. Thank you so much, sir. It's been, I know there's a lot to say.
Sorry. Sorry.
Yeah?
Sorry, I'm so sorry. I was talking too fast. I don't know if you could get the sense of what
I know you're very passionate about the topics, so I understand. So we would just run. We're out of time, so we would run through. Some of the questions that we've had, and so I'll direct this question to Dara, because I know WhatsApp recently issued a new privacy policy. Apple did as well, and Apple's policy, made a lot of noise. I heard that at some point that the Alibaba board had to meet because of the Apple policy. WhatsApp also did issue a new policy, and then NIDA issued an advisory to Nigerians. And so asking Dara to sort of just speak to, in in 30 seconds, Darren, could you just sort of give your perspective on the WhatsApp policy? If you have read about it. If you haven't, we can jump to another question and then you could supply the answer later on.
Okay, thank you, Nii. I have read the WhatsApp policy. I think it's very user-friendly. But to be honest, I think there's a lot of stuff that is happening behind the scenes that hasn't been communicated, or hasn't been adequately communicated to the end user. So from a privacy standpoint, it meets the threshold of transparency because the language is very easy to read and all of that. And they claim that all that they're changing is they're making it easier for end users to communicate with businesses. So nothing else changes. The data is still encrypted, and WhatsApp doesn't have access to the data and so on. But from my personal experience, having accepted, and it took me so long to accept, but having accepted the new terms, I felt it was a bit intrusive because when I went to Instagram, there were certain friendship recommendations that I saw and I was horrified. And I thought there's no way I should be asked to be these people's friends because they're in a completely different part of my life, and and I shouldn't be interacting with them on a social network. Yes. But yeah, that's my view. Thank you.
So you think it's user friendly? Okay, thank you very much.
Just user friendly. The next question I'll ask. Yeah.
Okay, so should we say yes to it or no? I mean, Nida told us to move to something else. So I mean, what's your answer? That's, by the way, I'm just putting you in. So my next question will be directed to Mr. Esom. And it sort of takes us back to the initial scenario that I gave. And the question, sir, is, could you sort of speak to competition law? Because you spoke to market definition, your presentation spoke to market definition in certain aspects. So could you sort of speak to competition law? I mean, from the businessman perspective now, as a weapon for the small guy. So on what basis would a new entrant to the market rely on this to target some of the big fish in the market? Because I know we have some small business owners here, and they will want to know how they can rely on this framework we are discussing.
Thank you very much, Nii. Yeah, I mean, it's an interesting way to look at it, to say, does the competition law give a small business owner a weapon, a tool by which to create space for themselves in the market? I think the theoretical answer is yes. Of course, you can go to the competition commission and say, Mr. X, Mr. Y, or big company Z is excluding us from the market by keeping hold of the information and not allowing us to participate. But then you have to be able to do several things alongside that. You have to be able to, first of all, prosecute that matter, which is not a simple case. It's not a simple matter in any case, right? Because usually the big guy you're trying to talk about, as I showed, is not someone who's in down in your jurisdiction. It's really someone who's actually, probably as large as the GDP of your country and is sitting down at headquarters in Ireland or somewhere else. And so prosecuting that kind of matter is usually going to be very difficult. So theoretically, yes. Practically, no. And right. And then if you look at the local environment, yes, perhaps the open banking framework, but that also is very straightforward. You can do that anyway. But I think it's very hard to attack an incumbent using competition law in these climes.
Thank you, sir. Thank you, sir. I would direct the same question to Chuk. So what's your perspective on that, Chuk? And because you spoke on the interplay as well.
Yeah, thank you, Nii. I'll take a different opinion from this. So basically, the whole idea of competition is show that the markets protected and not just the markets participate, looking at not.
Sorry, Chips, could you sort of speak? Okay, we lost you for a bit. Could you maybe come closer to the mic or? Yeah. Okay.
Sorry, can you hear me now?
We can hear you now. Yes, fantastic. Okay.
Okay, so the whole idea of competition law is to protect the market and the participants within that market. So they're concerned about market foreclosure risk for smaller organizations or competing businesses, or issues of reducing their incentives to compete in that market. So I think I'll take a different opinion from Mr. Eson. I would say yes, competition actually great. I mean, to really work to improve contestability or competition, market competition. It's very good to rely on in that respect. Thank you.
Oh, sorry. Thank you. I mean, I think that's. Well, I mean, that's a debate that we just don't have time to talk to now. Now, Dara, I'm directing the same question to you, but this time, because in your presentation you spoke to, you asked the question as to whether or not data protection laws would serve businesses, because generally, by default, they seem to preserve the interest of individuals as opposed to businesses. So, could you sort of speak to that question now? So, these data protection laws that we have, or the framework we have talked about, can they serve as, do they give any leverage to businesses as opposed to just individuals?
Thank you, Nii. So, yes, whether data protection law can protect businesses, no. The focus of data protection law is individuals and individuals' information, or information that relates to individuals, identifiable, natural. And the word natural is there to distinguish between legal person, i.e. companies, corporations, and so on. So no, data protection law is for individuals. Thank you.
Well, so as a follow-on, please. So I find that interesting, because then I will then ask, why are we having this conversation, right? Are we just being academic and considering moot points? I mean, what significance will this interplay we have discussed have for businesses who are playing in certain markets and have competition concerns?
Is that for me, Nii?
Yes, as a follow-on to what I had asked you earlier, yes, for you, Dara.
Okay, yes. So what's in it for companies? Yes, companies want to respect the privacy rights of individuals, because there's a lot at stake for companies. First of all, there's the catastrophic fines that companies could incur for getting it wrong with data protection. There's also the reputational risk. So so conceptually, data protection is an evolving concept. And there are people that in the data protection space that think that data is not the new oil. The new oil is trust. And that if individuals don't trust you, they will not give you their data to process. They will not patronize your business. So apart from the potential fines that companies could incur, there's also the risk of reputational damage, and also the administrative costs of getting it right. So say somebody wants to exercise their data, their individual rights, or they have a complaint that is data protection specific, and companies would then need to pay quite a lot of money, because data protection is quite a specialist area. And companies want to avoid spending that money to get somebody to help with data subject access requests or dealing with this complaint. And they want to focus on the core business, which is innovation or whatever. And data protection can be a bit distracting. So that's what's in it for businesses. I hope that answers the question.
Yes, thank you. Thank you very much. So I would just like to point out something, given the platform you're on. In my initial question, I had talked about the WhatsApp policy and the NIDA advisory. And I think I may have said that NIDA asked us to move to something else. So somebody in the audience has highlighted that fact. And so I just want to clarify that the NIDA policy or the advisory didn't say that we should leave WhatsApp. It just discussed the considerations and then sort of left it to Nigerians to choose what they were comfortable with. So thank you, Adora, for highlighting that point. Now, the next question I would ask, is from, we have a lot of questions here. So the next question is from Olushola, and I will direct this to Chu. So he's asking that where exactly is Nigeria? Because according to him, so he said, Nigeria, we don't produce ICT products per se on the scale of commercialization. So I guess he's saying we don't have companies as large as Facebook or Google and all of that. And so he's asking, what and where exactly is Nigeria on this? Pardon me, I'm just trying to articulate the question properly. So he's talking about data analytics. Okay, please, I think I'll pass on this one. It's taking some time to be clear on. Gabriel is asking about the Banjul Charter as to whether or not it provides data protection and privacy rights. Dara, can you answer that, or are you aware of the Banjul Charter?
Yes, sure, of course. But
Okay.
As far as I know, data privacy and data protection is not featured in the Banjul Charter.
Okay.
That's the simple answer.
Okay.
Thank you.
Thank you very much. We're closing out. I have a question for Chooks. And it's in respect to small businesses in Nigeria, right? Who leverage existing platforms to to provide services. So, for instance, you're a small business and you're using Facebook to advertise, or you're using Google AdSense to advertise. With this conversation we've had, where do these guys feature? Small businesses who are entering into sort of these relationships with these big entities, and what should they look out for to show that they are data compliant and they don't fall victim of any of these regulations we talked about?
Thank you. Thank you, Nii. Respecting the conversation we have now, which is about data privacy and competition, your question falls under two limbs. From a data protection perspective, it's a question of whether they are, this will be analyzed on a case-by-case basis. So it's a question of whether they are data controllers or data processors. And mere facts that they've taken delivery of this information, personal data from this platform, this implement of online platform. So it creates data protection obligations for them, under the NDPR, which they must comply with. So if they do not comply to it, obviously will expose them to liability from NIDA, who is the regulator. Then also, from a competition perspective, see that as being careful to ensure that you do not use this access to this data to stifle competition or innovation within relevant markets. Issues like, do you use it to undermine competition? Do you use it to erect barriers to entry for other firms? So these are the kind of scenarios we'll be looking at from both a data protection and a competition perspective, in terms of having this data, creating a partnership where data will be transferred from one organization to business players in Nigeria. Thank you, Nii.
All right, thanks. Chooks, the next question is to you as well. And so when you're discussing competition, right? We are talking about the fact that these big entities or these large companies or dominant firms have invested some amount of skill and resources in building out those data sets. And then, competition law or data protection, as it were, provides certain limitations. So could you sort of speak to the limits, that this frameworks, this framework gives, and the limit that it gives, and how, I don't want to say, and the fairness of this limits to the big entities. I know they say it's just business, but let's just talk the fairness element as well. Do you get the question?
Sorry, I think I lost you a bit. You just come back again on the question.
Okay, so in your presentation and Mr. Eson's presentation as well, right, we talked about the fact that, in deriving value from this data that these big firms analyze. They have spent money, they have, put in skill and all of that. Now we are putting in certain frameworks to limit, the exploitation of those resources, in the interest of the consumers. So now I just wanted you to speak to the fairness of that. Is it a fair position to take, or you get the question? So it's not a question, because I just want to get a perspective on that as well.
Yeah, I think the issue here, if they've been able to spend some money to harness this data, there is a question of whether does it give them a right in terms of intellectual property rights and the methodology or the techniques they used to harness this data. And if it's something that could be subject to intellectual property rights under Nigerian law, for instance, is it patentable or is it copyrightable? Yes, that could give them, some sort of covering as well, because it is provided by under law. But the thing is, there should be a limit, because obviously when you're exploiting intellectual property, intellectual property rights, the law is that also makes provision that on public interest basis, the states can intervene to claw back that right from you. So there should be a balance somewhere around that. Like I said, these are new issues. From the top of my head, this is what I'd say it looks like.
Oh, thank you. I think that sort of answers the question. Someone's asking if the presentations will be available. Yes, the session is being recorded, and we will share the link subsequent to this presentation. Now, my final question, before I go back to the speakers to give, their closing remarks, will be directed to Mr. Eson. And sir, could you sort of speak to business owners in the room, as to what practices or activities they would be involved in data-driven markets that could put them at risk with competition authorities? What activities could they be involved in that would be seen as exploitative? Because now that we have the FCCPC rule and regulations, and the acts as well, you would expect that at some point somebody will be on the lookout for some of the big firms, to make them responsible for some of the activities. So could you sort of speak to what these activities, or what example, they should look out for to avoid liability?
Thank you very much, Nee. That's a very interesting, and I think it's exactly the question we should try to answer. So we should ask ourselves, as Olusola Teniola's question was really around Nigeria's and Nigerian companies and their ability to generate the kind of data, or to have kind of a structure. So generating the data, aggregating it, and then analyzing it in a way that they're participating in data-driven markets was his question. Are we doing that? Do we have companies that are participating in the markets at such a scale that they're going to fall afoul of any kind of competition law, or even competition law in particular, as opposed to data protection laws, which they can easily fall afoul of? But for competition law, what is required is that they must have exclusive exploitative rights to some data, and that means you have the data. Companies that have such data in Nigeria today are not that many, but they are beginning to burgeon. There are more of them, and there will be people like the telcos, like the fintechs, and a few companies also working in specifically, let's say, data analytics for agriculture and things like that. These companies could be guilty of anti-competitive acts if they gather data and they keep them exclusively to themselves. For example, the telcos today have huge amounts of data that they're exploiting in particular ways, but are currently they're looking at individual data protection, as Dara has indicated, but not so much at the competitive angle of those activities. So to business owners, I would say it's a very topical area, very germane. We know that institutional investors like ourselves are beginning to ask those questions, especially when you're making acquisitions. especially when you're beginning to make new investments, other companies, and when you are gathering data to use, you have to be very careful that you do not cross the line. So it's a point where you have to actually ask for some additional expert advice subsequent to this kind of very high-level discussion. Thank you, Nii.
Thank you very much, sir. So I think we're coming towards to the end of this conversation. I mean, we could go on for a while, but sadly we have just about 6 minutes left. So I would just ask to speak to one issue or two issues. I'm not asking you to make predictions now, but what are the things you would want the audience to look out for, in their businesses, in their personal lives, with their personal data? Should they disable all the apps on their phone? I mean, I hear now that the Apple privacy policy enables you to prevent your app from reading your metadata or something like that. I mean, I stand to be corrected, but it was something that caused there was a conversation about it on Twitter. So could you sort of just speak to one or two issues, 1 minute each, please, that the audience should look out for after this conversation? So Chooks, could you go first?
Thank you. Thank you, Nii. I don't know if I'm audible and if I'm visible.
Yes, I can hear you.
Okay, so basically, we've spoken about data protection here. We've also spoken, so what I have for the audience, especially business owners, this data is to, obviously, it's very fundamental here. When having access to this information, make sure that it's a lawful basis using that information from a data protection perspective. Then also, under Nigerian data protection law, there may be, and there's a likely scenario that you would need to conduct data protection impact assessments. What that does is it analyzes the data protection risk in your data processing operations and tries to create risk mitigation strategies, so that you don't run afoul of data protection risk or expose yourself to data protection risk. Then from a competition perspective too as well, when you use the data, try as much as possible. Obviously, if you have multiple platforms, you obviously need to look and create a scenario where you facilitate choice, giving the consumers a choice and the opportunity to make decisions about how they intend to the various aspects of your platform, especially when it concerns accessing data. So that's just what I have to say about this. Thank you, Nii.
Thank you very much, sir. Dara, could you sort of speak to one key takeaway?
Thank you, Nii. Very quickly, one of the ways that data protection law can promote competition law objectives is to expand the data portability, the right to data portability, to include not just volunteer data, but observed and inferred data. And I think the time to do it is now, because the data protection bill is going through the legislative process. Thank you.
Thank you very much. And finally, Mr. Esau, what would your key takeaway be?
Well, I think there are two things I'd like to talk about. One is that individuals need to pay more attention to the consents they give and try to understand what risks they take when they say yes to all the things they say yes to. So it takes some time to learn, not from reading the detail, but from discussions like this, what you are doing when you just consent to all the things that companies ask you to do. So that's for companies. For organizations, I think there are many organizations in Nigeria that are dealing with personal data. And as Dara has emphasized, they need to be very aware of the bill that's passing right now and protect themselves and make sure to take all the steps needed that they do not become subject to some kind of litigation from handling personal data in this country. Thank you.
Thank you very much, sir. And for me, I think it's also just to highlight the fact again that there is a bill before the House which could pass very soon, and it will, it has the results it's that it would, set up certain structures and set up certain obligations for companies and individuals going forward. So I think we should all be on the lookout for the bill when it comes into law. And there's definitely going to be increased activity in these spaces. And I think businesses and individuals should position themselves to take advantage and also to protect themselves. So thank you so much, ladies and gentlemen. It's been very engaging. I'm sorry that we couldn't take all the questions, but we will provide the answers in your email. And having said that, I would hand over to Joanna. Thank you, thank you, thank you.
Thank you, Nii, and thank you to StreamSours and to all of our speakers today for such interesting insights. I found that a really, really interesting discussion. So thank you again. Unfortunately, as Nii said, that is all we have time for today. We did receive a huge number of questions that we haven't managed to get to. And if you do have any follow-up questions that you didn't get to ask, please do get in touch with the firm directly using the contact box on your screen. So have a great rest of your day, and I hope to speak to you all again soon. Thank you again, and goodbye.